Thank you.
I changed my mind. I'm just going to go straight into closings if that's okay with the court.
Sounds great.
Thank you.
Then what I'm going to do is, AJ, I hate to be a pain. There won't be any need for a Zoom. Can you switch it back over? Is that too much of a, are you okay? Is it okay like this?
You want to just leave the meeting then?
I'm leaving, yeah. Let me know when you're ready.
Good to go, Your Honor.
Okay. Let's bring in the jury.
Jurors are in the courtroom, Your Honor.
Thank you. All right, welcome back, members of the jury. Everyone may be seated. All right. Members of the jury, both the state and the defense have now rested their case, and the attorneys will be presenting their final arguments to you. Before they do, I need to let you know that you need to remember that what the attorneys say is not evidence or your instruction on the law. However, you should listen closely to their arguments because they're intended to aid you in understanding this case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. I turn the case over to the state of Florida. Ms. Stifler?
May it please the court?
Yes.
Counsel?
Yes, ma'am.
Jared Bridegan never saw it coming. He was unarmed, unaware, exposed, vulnerable, He had no time to prepare for death. And he couldn't have known on that cold asphalt in February of 2022 that the architects of his murder had been making preparations for his death for months. You have been attentive jurors over the past week and a half. Your job has been to listen to the evidence, and your job will be to render a verdict. The state of Florida's job is to present you with evidence and prove the charges we've indicted this defendant on beyond a reasonable doubt. The defense attorney's jobs are to test the evidence and defend their client. You are here to discover the truth. That is what justice is. The truth of what happened to Jared Bridegan on February 16th, 2022, and who is responsible. This is a court of law and reason, as I said last week, not anger or emotion or prejudice or sympathy or bias. What happened to Jared Bridegan in front of his daughter is awful. But your emotions must not rule your verdict. It must be based on the law and the evidence. And your role is to answer two questions. Was a crime committed? And did this defendant, Mario Fernandez, commit that crime? The law allows you to make reasonable inferences from the evidence. You have heard a lot of witnesses. You have seen a lot of exhibits. And I'm going to go through some of the law the judge will instruct you on and the evidence that you have been presented and show you how we have proven our case that this defendant is criminally responsible for the planning and the preparation of the death of Jared Bridegan. One of the instructions the judge will give you that I want to keep in your mind while we go through the evidence is the law on reasonable doubt. Reasonable doubt is not a mere possible doubt, a mere speculative doubt, a hypothetical doubt, a forced doubt. It's not a guess, conjecture, and the law does not require proof beyond all doubt. I tell this to you because during the course of this trial, through cross-examination, the defense opening, and what I anticipate they will argue, is that you will be asked to speculate, you'll be asked to imagine, you'll be asked to conjure and guess as to alternate explanations for the evidence presented by the state. And if you are back there in that deliberation room saying to yourself, maybe, what if, possibly, you are straying from the law that the judge is going to instruct you on. Reasonable doubt means that it is based upon reasoning and common sense after a careful and impartial consideration of all of the evidence. The most important thing I will talk to you about today is how the evidence relates to each other, how the evidence should be viewed in its totality, and how the evidence in its totality is overwhelming against this defendant. Was a crime committed? You're going to be instructed on two crimes, murder in the first degree and solicitation. And I don't think, you've already heard, that there's any dispute that Jared Bridegan was killed in a premeditated first degree murder. He's dead. It was a criminal act, and it was premeditated, meaning that there was a conscious decision that Jared die. You know that based on how he met his end, the manner in which he died, and the fact that Henry Tenon fired 4 10-millimeter bullets at him, 2 of them striking and killing him. The law doesn't require a fixed period of time to form this intent, but you know, based on the evidence, that those plans, that preparation, and that intent was formed long before February 16th. Premeditation. 4 gunshots in a row, execution style. There is no doubt that Henry Tenon pulled that trigger. The defense has conceded it. The state has proved it. You saw it yourself on that video. There is no doubt that Henry Tenon shot Jared Bridegan. But in this case, not just one person is guilty, because this crime is not a crime that is committed by one person. I said at the beginning of the trial that this is real life. There's been a lot of talk throughout this trial and at jury selection about the presence of media, about podcasts, about true crime, about TV shows. And I talked to you about the manner in which Jared Bridegan died in my opening statement to remind you that a man, a real man, was wiped off the face of the earth on a dark road, on a dark street, on a February night for no reason, or no good reason, no justifiable or legitimate reason. Lying on the pavement, dying, while his 2-year-old daughter is panting in her car seat, wondering if the police are going to help her daddy, ice cream still sticky on her mouth. One thing, though, that I will say podcasts and TV shows and books and movies get right about crime is this idea, common sense idea, even absent the instructions the judge will give you, which she will instruct you that you can and should use your common sense. This idea of means, motive, and opportunity. Not elements, something that you all know intuitively as human beings and as jurors, and something that you intuitively can see in this case when you look at the totality and look at the big picture. Consciousness of guilt. And here's the thing. Henry Tenon had none of those things. He didn't know Jared Bridegan. He's a convicted felon who's basically homeless, squatting on people's couches with an overdrawn bank account and no access to firearms, who doesn't go to Jacksonville Beach other than the times where he is hunting Jared Bridegan. Henry Tenon didn't have motive or means or opportunity, absent one person. We started this case with the ultimate question: who did? Who had these things? And standing here a week and some days later, the answer should be clear to you and proven to you beyond a reasonable doubt. This defendant, Mario Fernandez, and his wife, Shanna Gardner. I want to talk a little bit about the idea of criminal solicitation. But one thing I want to talk about before we get there is that the defense made some arguments or statements to you in their opening statement and fleshed those out through cross-examination. And there were 3 things they said that I agree with, that you should keep in your mind as you view the evidence. The defense in opening said, and in jury selection said, just because you know a wrongdoer doesn't make you a wrongdoer. That's true. They said that the defendant, Mario Fernandez in this case, didn't really have a motive, that the divorce wasn't that bad, that there really weren't child custody issues, and therefore it's inconceivable that he would commit this crime. I agree with the idea that if you don't have a strong motive, it does not make sense that you would commit this crime. Which lends you to, as we get down, what I mentioned earlier, that Henry Tenon had no motive. It makes no sense that he, on his own, independently and alone, would commit this crime. And lastly, the defense argued through cross-examination, and you recall those many, many poll camera clips, that distancing yourself from somebody looks guilty, and not distancing yourself from somebody doesn't look guilty. And I agree with that concept, consciousness of guilt. But in this case, Mario Fernandez did distance himself from Henry Tenon and John Biggerstaff and 5239 Potomac Avenue when he realized the police were closing in on him, when they arrested Henry Tenon on August 18th of 2022. Up until then, he didn't think they would ever get caught. This plan was designed specifically so that it would never tie back to Mario Fernandez, using a random tenant without a lease, without lawful residence at that residence anymore, with checks, with subject lines that wouldn't draw too much attention out of a business account, until it didn't, until they figured it out, until by a stroke of luck, an act of God, good detective work, boots on the ground, never giving up, going everywhere, trying everything, talking to everybody, finding that tire at Potomac Avenue. And then in August 2022, that's when this defendant began to distance himself. And you all saw the evidence, and I'll discuss that. So 3 things I agree with. Mere association with a guilty party doesn't prove guilt. But close association with several guilty parties, that's harder to explain. Motive, even though it's not required, can tell you who committed a crime. And consciousness of guilt, hiding evidence, destroying evidence, is evidence of guilt itself. First-degree murder, the law is very simple on that, and it's not going to be in dispute that Jared Bridegan was killed with an intent to kill him. Criminal solicitation is the other charge that Mario Fernandez has been indicted on, and that requires that he solicited Henry Tenon, meaning he commanded, encouraged, hired, or requested him to commit this first-degree murder. There are 2 distinct crimes under the law, murder in the first degree and solicitation. Your verdict is separate on both. But a large majority of the evidence we presented applies equally to both. The solicitation is the ask. You earnestly ask someone to commit murder or to engage in specific conduct. You don't ever have to lift a finger to help. It is the ask, a genuine, earnest ask. It doesn't require that the act be completed. Somebody can ask somebody to kill someone for them, and it never happened, and they never do anything about it. And if you believe they asked that person beyond a reasonable doubt, even though it didn't happen, and even though they didn't lift a finger, they can still be found guilty under the law. Solicitation is the ask. Principle to murder is the completion of the act. The ask and the act. Here, both happened in this case. He is guilty of both because he asked, and he is guilty of both because it happened. And he helped, and he incited, and he encouraged, and he hired, and he solicited. 2 of the other things we have to prove are the dates of the crimes. I'll get into that. I have a timeline to show you. The murder, February 16th, 2022. There's no dispute there. Everybody is in agreement. Jared was shot and died on scene there on Sanctuary on February 16th. Criminal solicitation, the state has charged a range from November of 2021 to the act, the completion of the act on February 16th, 2022. We also have to prove venue. That means that we have to prove this occurred in Duval County, which you all know. Multiple people testified this was in Duval County, just north of that St. Johns County line in Jacksonville Beach, Florida. And the reason I bring all this up is because I want you to be clear on what the law requires and what it doesn't, which is the state has to prove, was a crime committed, did the defendant commit it, date, and venue, where it happened. So you've got the who, the what, the when, and the where. The law doesn't require us to prove the why. The law doesn't require motive. But in this case, the why proves the who. So I'm going to get into how it is that the evidence has shown that this defendant participated in the murder of Jared Bridegan. The principal's instruction. This is something the judge is going to give you. And this is something Mr. Mizrahi talked about in jury selection with that example of the bank robbery, where you have the getaway driver, you've got the bag man, you've got the guy holding the gun while they're sweeping the money into the bag, and you have, like in Ocean's 11, the guy with the blueprints of the bank and how to get in, off in Cabo enjoying himself. They are all equally culpable under the law. They may not be punished the same, but they are all equally culpable under the law because they are principals. So the state, in this case, doesn't have to prove that Mario Fernandez was at the crime scene, that Mario Fernandez pulled the trigger, that Mario Fernandez was in the proximity of it. We just have to prove that in this time frame, he intended that Jared die and that he did something or said something that was intended to and did incite, cause, encourage, assist, or advise Henry Tenon. And all of you must render a unanimous verdict. When you're considering first-degree murder and whether he incited, caused, encouraged, assisted, or advised Tenon, you all have to be unanimous that he is guilty as a principal for doing one of those things. You all don't have to be unanimous as to which of these things you personally believe it falls under. You can believe he paid Henry Tenon to do this. You can believe he encouraged him by showing him what Mr. Bridegan's vehicle looked like. You can believe that he drove the truck that night. You can believe he gave Henry Tenon the gun. It doesn't matter which fact you believe beyond a reasonable doubt this falls under, as long as all of you believe he did something or said something that is one of these things. That makes him guilty under the law, and you can return a verdict of guilty under the law. He doesn't have to be present when the crime is committed. He doesn't have to know under the law how every detail of the crime will be committed. If he had that intent and did or said something to do one of those things, assist, encourage, incite, then he must be treated as if he was standing there holding that 10 millimeter, pulling that trigger 4 times until Jared Bridegan died face down on that pavement. The law is written in this manner for this exact scenario. A murder for hire, a way to distance yourself, an outsourcing of your dirty work so that you are never traced back to it. That is why we have this law, because the law contemplates that there are situations like this, and the law understands that someone should not be able to get off completely scot-free and never be held accountable because they outsource a murder to somebody else. Again, I said the judge is going to instruct you that you're allowed to use your common sense, and you should. You brought it with you here today. You're not going to leave it here in this jury box when you go back into this deliberation room. So look at the evidence, understanding it in a reasonable manner, looking at it with common sense, and deciding what it means. And to do that, the law gives you guidance. The judge will instruct you on how to weigh the evidence. The testimony of witnesses is evidence. The exhibits before you are evidence. It is not the question asked by the attorney to the witness, but the answer that they receive that is the evidence. When you look at witness testimony, you look at, do they know what they're talking about? Did they see and hear and know what they are describing? Are they accurate in their memory? Do they have a bias or an interest in how the case should be decided? That is important because if somebody is tailoring their testimony because of an interest, you need to consider that as to whether you believe they're credible, reliable, and truthful. Have they been promised anything for their testimony? And does their testimony agree with the other testimony and evidence in the case? They listen to a witness and their testimony doesn't agree with other evidence, and they have an interest, personal or otherwise, in making sure that their interest is protected or the defendant's interest is protected. You get to decide how much weight you give their testimony. You can give it some, you can give it none. So I want to go through, I know there was a lot of very dense testimony, a lot of technological, digital evidence, a lot of surveillance, phones, cell site. You all got quite the education this week in the plethora of evidence available to modern law enforcement. And I want to go through and explain from beginning to end how it all connects, how it all adds up. And I think it makes the most sense to start chronologically. From 2018, when Mario Fernandez married Shanna Gardner, up until the murder in 2022, there were years of animosity between Ms. Gardner and Mr. Fernandez and Mr. Bridegan and his new wife. You know that. You know that from the testimony of Taylor Kudis, who told you Mr. Fernandez complained to her about a high conflict custody issue. You know it from the testimony of John Biggerstaff, that the defendant said the child custody dispute was putting a strain on his marriage with Ms. Gardner. You know it from the court filings. There was some cross-examination with Detective Johns about the court filings and how they weren't that petty, they weren't that acrimonious, but you can look at them. These people are litigating everything. Who should pay for half of an oxygen tank for their kid? It was not a pleasant and happy and copacetic situation. And you don't have to take my word for it, and you don't have to take their word that it wasn't. You can listen to the defendant's own words in his recorded interview.
The primary goal, because it wasn't amicable and because of how they're being with the kids, we were more or less fighting for the kids to have a chance and for Shanna to have majority decision making. And if she could have more timeshare on her end, if it was like 60-40 or whatever, if we could bend it just enough, it'd be great because the kids would be better off.
Right.
You know, and if we could push them into the corner of all the interaction with the kids, we all need to be together.
Yeah.
So they could just suck it. And I don't care if they're suffering because they're uncomfortable. I'd much rather it all be right there in one. So if they say something dumb, I can immediately. I'm confrontational. I don't care about that. So I could be like, no, hell no, dude, we're not doing that.
Right.
And I can shut him down, and the kids can see, hey, like, not this. We can do it this way,
right.
And we'll all be here. So there's no, oh well, they said no. That shit was just so annoying to me.
The defendant himself said there was custody issues. They wanted majority decision making. They wanted more custody, even 60-40. He is at an interview with police 13 days after Jared Bridegan has been shot and killed, and he is going on and on and on disparaging Jared Bridegan. He calls him a keyboard warrior. He says that they can suck it. He's talking about a dead man to police in a murder investigation. It is clear there was no love lost between them, and it is clear from his words, not their argument, that they were seeking more custody. And you heard that too from Mr. Fernandez's own friend, Carlos Fong, said. It was incessant. Shannon was always talking about she wanted more custody, she wanted more custody, she wanted more custody. The witnesses they called, the teacher, Ms. Meredith, said she was aware that they wanted more custody. He acknowledges years of conflict.
Well, what could we tell them? And I told her, I was like, we tell them what we know, which is our interactions with Jared, how Kirsten is being a total bitch right now, and how this has been. For me, this has only been for 4 years.
Mm-hmm.
For Shannon, it's been like 7-8 years. And then before the divorce, it was everything that she dealt with him.
Right.
Years of animosity suddenly
So, like,
solved.
certain things are happening where it's like, oh, well, we're going to do this. And it's we don't have to do that anymore.
Mm-hmm.
Like, we don't have to do that anymore because there's no split.
He was talking about how the kids' new normal with Jared gone is asking about the things their dad used to require or their dad used to want. And his statements are, we don't have to do that anymore. He's gone 13 days after. And listen, I am not here. I'm not a family law attorney. My client is not Jared Bridegan or Kirsten Bridegan. My client is the people of the state of Florida in a murder. I don't care if Jared Bridegan was the most petty, obnoxious, keyboard warrior jerk during a divorce and custody battle. That's not before you. It doesn't matter if they were completely right about this situation or completely wrong. What matters is how they fixed it. They fixed it by executing a man when they had other alternatives available to them. That's why we're here. Don't get caught up in the pettiness and the drama, who's right, who's wrong, who's good, who's bad, who's nice, who's not. What matters is, did this defendant take matters into his own hands to solve this problem? To tell them to suck it, to have more custody. They don't have to do this anymore. There's no split anymore. So there's years of animosity. We know that from the defendant and the rest of the evidence, and that all corresponds and agrees by witnesses that have an interest in protecting Mr. Fernandez said it themselves. His friend, Carlos Fong, the witnesses called by the defense, the kid's teacher, his former fling/friend, Miss Kudis. So you can consider and his own words, you can consider those statements and that evidence of this animosity reliable because it came from multiple witnesses, including the defendant, who have no reason to help the state of Florida. And it came from Mrs. Bridegan as well. Kirsten Bridegan admitted it was bad and there were pettiness on both sides. So we're moving now to November 21st to December 21st. We know from Mr. Fernandez's, again, own statements and the testimony of the detectives that Henry Tenon was living at 5239 Potomac at this point. We also know that the defendants had made statements about how Mr. Tenon was constantly behind on his rent. He could barely scrape the money together.
Right away, like, just you can pay like week by week kind of deal, but you got to make it up. And then I want to say it was either September or October time frame. It's so fucking long ago now that he flat out told me, he's like, I can't fucking afford it anymore. He just couldn't.
So he just left, yeah.
Yeah, well, the thing was, I told him, I was like, well, how about, what can you afford? And like, the dude was like scrapping up like 300. And then I told him, I was like, if this is where you're at, I can give you till December. And after December, like, that's it. And the thing was, like, I had a new tenant come in January.
So we know that, according to Mr. Fernandez on that wire call with his friend, that Henry Tenon was evicted in December. And we know that Henry Tenon had no money and couldn't pay his rent. And yet, Henry Tenon was still living at Potomac for some period of time after this eviction in 2022. And a man who couldn't even afford his rent and was behind in his rent is receiving large sums of money for Henry Tenon, large sums of money, like several months' salary from this defendant. And we know that Henry Tenon and Mario Fernandez had significant contact on January 4th, 2022. We know that from the phone records. They were in contact. He's getting evicted. Why are they communicating so much in January and February and March when he's no longer a tenant? It's because they are discussing January 5th. This is where the solicitation comes in. You have evidence beginning from the defendant, again, own words. He's evicting this man, he can't pay any money. And then magically in January, Henry Tenon is driving around Jacksonville Beach, the same route of the homicide, on a date night when Jared Bridegan would be in Jacksonville Beach. You would have to know about date night. And you have to know that Jared would be there. And you have to know where to look for Jared. They met up. The only texts left on Henry Tenon's phone happened to be from this date, which is lucky for us. January 4th, 2022, from Mario Fernandez to Henry Tenon. Heading your way. Okay, I'm here, brother. The timing of everything. Individually, I want to be very clear. Individually, the defense can take any one of these points, any one of these exhibits, any one statement from a witness in a vacuum on its own, excised from the rest of the evidence. And of course, there's always going to be an innocent explanation for every one little thing. And I'm not saying the fact that Mario Fernandez went and met up with Henry Tenon on January 4th makes him guilty. What I'm saying is it is interesting and suspicious and evidence in the totality of everything of his guilt that he meets up with him the day before Henry Tenon goes to Marsh Inlet, where Mario Fernandez lives, to Shetter Avenue in Pablo Hamlet, where he waited that night for Jared to commit that murder. And down Fairway, the same route that homicide truck took that night, the same route where there are no cameras, the same route where you can look for somewhere to sit and wait for somebody, like Cradle Creek, a nature preserve with a parking lot and no cameras, and a view of 15th from Marsh Inlet where you could see someone's headlights and car easily. That's what you have to consider, not in its individuality, but in its totality. So on January 5th, we're in the time frame of the date range for the solicitation. How would Henry Tenon know about date night? That is something I want you to really think about, and I want you to really use your common sense, because there was a cross-examination question by Mr. Dreiser, I believe, of Detective Johns, that date night is litigated in all these filings in the St. Johns County Family Law Clerk of Courts. And you can ask yourselves if you think it's reasonable that Henry Tenon is logging on to the St. Johns County Clerk of Courts family law case, pulling up individual filings on time sharing and parenting plans, and reading the details, and then plotting a map of where he should be. You decide if that's reasonable. I would submit to you it's not reasonable. It's ridiculous. Henry Tenon knew about date night on January 5th and this location and this route because
Yes.
thought that Henry Tenon was reading filings and then plotting on a map and devising this plan is not reasonable. It's ridiculous. And it causes you, or asks you, to conjure, it asks you to rely on conjecture and speculation and imagination, and that is not what the law requires of you. And it's actually what the law forbids you from doing. Somebody had to tell Henry Tenon about date night in these locations and these routes right next to Mr. Fernandez's house. And your common sense and the totality of the evidence leads you to the conclusion, beyond a reasonable doubt, that that person was Mario Fernandez. But it's not just Mr. Fernandez's connection to Henry Tenon. He also is connected to John Biggerstaff. John Biggerstaff, who happens to own a Glock 10 millimeter firearm that can't tell us where it is, can't produce it, can't find it, despite the fact that he is a self-proclaimed gun enthusiast, former JSO reserve officer, 20-year Navy veteran with 20 firearms. I don't know where any of them went. My son kept them in his car for a few months. My son, the police officer, just kept 20 guns in his car for a few months without checking on them ever. We took them to someone's house. I never saw them again. I didn't think about selling them, even though they're valuable, even though guns have value, even though his son could have legally sold them. His son, a police officer, and him, a former police officer, are just so careless with a killing machine, a lethal weapon, when they are trained and know better. Knowing a wrongdoer doesn't make you a wrongdoer. Knowing two wrongdoers is a little harder to explain. And there's no dispute that Mr. Fernandez, the defendant, and Mr. Biggerstaff had a very, very strange relationship, as you all heard come out during cross-examination and defense opening. But that connection to that firearm is what makes, in the totality of this, the defendant's guilt that much stronger. Because here you are, you're getting more and more and more and more pieces of evidence that individually, again, can be explained away, but together becomes much, much harder to come up with an innocent explanation or to look at these in a reasonable way that doesn't suggest overwhelming evidence of his guilt. On January 25th, we know, because of technology, that Mr. Biggerstaff and Mr. Fernandez were together at Mr. Biggerstaff's home. Mr. Biggerstaff testified that Mr. Fernandez came over and he just can't remember what they talked about. 2 weeks before the homicide, he can't remember what they talked about, and he can't remember Googling Glock 10 millimeter firearms, 10 millimeter Glock pistol, 10 millimeter Glock pistol, pin on hidden gun case, after Mr. Fernandez left his residence. Mr. Biggerstaff, remember earlier when I talked about the weighing the evidence and the memory and the interest and the bias? You can decide how credible you think Mr. Biggerstaff is in giving this helpful testimony to his buddy that he couldn't remember ever discussing a 10 millimeter with him, just a coincidence that he was Googling it. But on defense cross-exam, Mr. Biggerstaff could recall with excruciating detail every single minute of his slip and fall, from the fact that it was a 4-foot sign next to the breakfast sandwiches. He could recall every other Google search he did. Yeah, I remember Googling flour tortillas, and I remember Googling yachts in the south of France, and I remember Googling military bases. 10 millimeter? Oh, don't remember that. I do remember Googling a 9 millimeter because I know that's not the firearm used in this homicide. But this one, don't remember, don't know her. These gun cases and hidden furniture, that's from my drugs. Even though, and he remembers that, even though it says pin on hidden gun case in these searches. So that, we're talking close in time. We're talking weeks before the homicide. This defendant is going to Henry Tenon's home, who's evicted, no longer a tenant. The day after they meet up in person, Henry Tenon is driving past Mr. Fernandez's house, driving past Pablo Hamlet on a Wednesday night date night. Week before the homicide, 2 weeks before the homicide, Mr. Fernandez is going to Mr. Biggerstaff's house where he's Googling how to hide a 10 millimeter in furniture and Googling 10 millimeter firearms, searches that he can't recall, just like he can't recall where that gun is. In totality, there is no other reasonable inference than these people are planning this murder. They're planning to use a 10 millimeter, that's what was used. They're planning when it would happen and where it would happen. That's why Henry Tenon drove that route. They're planning who was going to be killed, and the only person with a connection to Jared Bridegan between those three, Biggerstaff, Tenon, and Fernandez, again, this defendant. The connection, the spoke in the wheel that turns that plan to its eventual execution and completion. Then we get here to January 29th. I have here the, quote, dry run. That is what Mr. Dreiser asked Detective Johns or Lindsay Butler. Is this what you would call this, a dry run? It's a pretty good name for it because it is sort of a dress rehearsal for committing a homicide. This is what you might call scouting the scene, scouting the victim, casing the joint, whatever you want to call it. This is what happens. Henry Tenon's two devices, his phone number ending in 7612, his other phone with Henry Tenon 53@gmail.com, go from his house where he's squatting at Potomac Avenue, because at this point we know Jeremy Ordway has moved in. You remember the lease defense put into evidence was dated January 27th. So Henry Tenon is evicted at this point, and there's a new tenant. And yet Mr. Fernandez arrives, or is possibly co-located, if you want to use expert testimony jargon, at Potomac Avenue right before Henry Tenon drives all the way to St. Johns County. We know he's in that blue two-tone truck, and we know Mr. Fernandez is coming to Potomac, and Mr. Tenon is leaving and then coming back while they're co-located again in that same truck. Mr. Fernandez, as you saw from the poll cam footage that the defense put in, would go to Potomac in his Tundra, park on the street, and Henry Tenon and Jeremy Ordway's cars would be parked right there in that driveway. Although in August of 2022, the truck's broken down, so Henry Tenon's driving that Crown Vic. But you know from their evidence that they said is great evidence of habit and history and usage of this residence, you know Henry Tenon parked in that driveway when he was there, and you know Mario Fernandez parked on that roadway when he was there, and you know Henry Tenon was in this truck before the murder, and you know that truck was released to the media, and you know that this defendant didn't say anything about his tenant owning a blue two-toned Ford F-150 when he talked to police on April 1st, 2022. That's what's important about this. Multiple things about this day. Maybe individually, your tenant owning a truck that you might not know about, not bad. Going to the house when your tenant's in that truck, a little worse. Going to the house when your tenant's in that truck who then goes down to AB's gymnastics studio and the street where the victim lives, really bad, really hard to explain, really doesn't make sense unless you are in that truck with that tenant, telling him where to go, telling him who to look for so that he knows exactly who he's supposed to execute on February 16th. The biggest thing about this, too, is this is the defendant's own words that let you know he's the one that told Henry Tenon about this. Because I don't think, and you can check me, you can go through every filing you want, and you can go back in your mind over the testimony, that anywhere in that parenting plan or in that date night was it stated the location and the habit of Jared Bridegan to go to this gymnastics studio and go back to his house. So that is where Henry Tenon went, past this gymnastics studio, and then to the street where the victim lived. And if you look at the time on those maps, you can see that he's traveling like he's on a highway, and you can see that the distance between those data points, the time between those data points, is not enough time that he's stopping somewhere. He's not going to a medical appointment or a business. He's not going out to dinner. He drives straight there, drives around, and then drives up to the crime scene. How would he know to look for Jared at the studio and then at his house? How would he know?
Abigail has told us, like, that he just drops her off and then leaves, goes home, then comes back, even though they live, like, 5 minutes away.
The defendant himself told police it made him angry. It annoyed him. He complained about it. He's trying to make Jared look like a bad dad. Listen, he drops AB off at her gymnastics, and he doesn't even stay. He doesn't even stay to watch her. He drops her off, he lives 5 minutes down the road, and then he goes to his house. What does Henry Tenon do this day? Goes by the gymnastics studio, and then goes by Jared's house. That is not a coincidence. That is not an accident. He was searching, he was looking, he was hunting, and he was told by this defendant about that habit of Jared Bridegan, because there's no other way he could have known. Then, after leaving Potomac, where he no longer legally resides, going by the gymnastics studio, going down the victim's street, he goes up to the crime scene, the eventual crime scene where Jared would be killed. And while he's doing this, the defendant's phone is in the vicinity, in these bands at Potomac. That's what those bands mean. It can be within 1 to 2 bands. He is at the Potomac residence. But what is interesting about this is all his phone is recording what we talked about. These timing advance means that your phone's communicating with the tower and it's taking measurements without you doing anything actively. There's no cellular usage. And cellular usage, meaning what tower you're using, is different. Remember, timing advance is a network-initiated activity. T-Mobile is pinging your phone, so to speak, and sending back information about how far you are away without you doing anything, as long as it's on or not in airplane mode. You, if you are using your phone or texting or calling or doing anything, create data on cell towers. And Mr. Fernandez's phone is not creating any data. It's not interacting with the cellular towers. It's not making calls. It's not sending text messages. And on its own, a period of time when your phone is not being used isn't suspicious. It isn't evidence of guilt. But the totality of your phone staying in one area and not being actively used by the phone holder, by the defendant, while Henry Tenon is driving down to an area only Mr. Fernandez would have known to tell him about, that is evidence of guilt. That only has one reasonable conclusion, is that Mario Fernandez got in that truck with Henry Tenon and went down to show him Jared Bridegan's vehicle in St. Johns County, and then up to show him the eventual homicide scene. And we know that because as soon as Henry Tenon arrives back at Potomac Avenue, Mario Fernandez's phone leaves 3 minutes later. That timing, he arrives, they overlap for 2 minutes. That's plenty of time to hop in someone's car. Henry Tenon's truck, in that truck, does this whole route, comes back. 3 to 4 minutes later, Mario Fernandez leaves. That can't be a coincidence. That is evidence of what they were doing. That is evidence of this plan. That is evidence of the preparation. We're moving along. February 15th, this is an important date because this is the day before the homicide. And it is important because the defendant, again, has contact with 2 of wrongdoers, as defense would phrase it, in the same day. It is significant. It is of evidentiary significance that Henry Tenon, the shooter, and Mario Fernandez are together the night before the murder. You saw a map. I don't have it here, but you can look at it. They are together at Potomac. Their devices are co-located for over 27 minutes, about 27 minutes. And we know Henry Tenon at this time is driving that truck. So there's 27 minutes, Mario Fernandez at Potomac with Henry Tenon. And then Mario Fernandez leaves Potomac, and that night he goes to the home of John Biggerstaff, the person who owns an unrecoverable, unfindable Glock 10mm firearm. And you heard some very unpleasant testimony about what Mr. Fernandez was doing there that night, but it is of evidentiary significance that he is having contact with two people with connections to that scene. The truck from Henry Tenon, the gun associated with a similar gun that Mr. Biggerstaff owned that he can't produce. This defendant has contact with both of them the night before Jared Bridegan is killed. That is significant. Individually, contact with one, contact the other can be explained away. Together, there's only one reasonable conclusion. They are perfecting this plan. February 16th, of course, Tenon murders Jared Bridegan. That's Henry Tenon. This is the part where I want to remind you of that instruction from the judge that she'll give you about principles. It is not necessary that we prove Mario Fernandez was present when the crime was committed. All we have to prove is that he encouraged, incited, assisted him, whether by explaining date night, by telling him who Jared was, by showing him the car, by giving him the gun. You can find him guilty based on that and that alone. You don't have to believe beyond a reasonable doubt he was there. But we know there were two people at the homicide scene that night. Henry Tenon on foot and somebody driving that truck. Who would Henry Tenon bring to commit a murder? He had to go commit a murder with someone. Who would he trust? Who would he bring? You don't bring a witness to a murder, you bring a co-defendant. Do you know why? Mutually assured destruction. You got to trust that that person and you are going to keep your mouths shut. And how can you do that? You can only do that if that person is equally guilty, equally culpable, and wants the same objective you do. And nobody wanted Jared Bridegan dead. Nobody that the evidence uncovered or the investigation uncovered more than this defendant and his wife. So if you're Henry Tenon and you're going to kill Jared Bridegan and you need help with it, you bring someone who wanted Jared Bridegan dead, who wanted to see it happen, who wanted to see it successful, and who wouldn't rat you out later. Mutually assured destruction. Henry Tenon had very few close associates. You heard from his phone records he had a girlfriend, Peanut. He had Jeremy Ordway, his roommate, and he had Mr. Fernandez, who he is in frequent contact with during this time frame. And you saw in Mario Fernandez's phone that Henry Tenon, although his contact was deleted, that Mario Fernandez had a contact, Jerry at Potomac, Jeremy Ordway. And you will see that the phone number for Jeremy Ordway in the defendant's phone matches a phone number that was calling Henry Tenon's phone that night. The phone here by this green tower. While Tenon, who's on foot at this pink tower, these dots. We know he's there from the surveillance. We know he's there from the cell site with that phone linked to Henry Tenon 53. His phone for 7612 is using this green tower. And Jerry Ordway is calling this green tower phone during the homicide. And we know the truck, the person driving the truck, is separated from the person on foot. So if Jerry Ordway is calling this phone, that means it ain't Jerry Ordway. And if you eliminate Jerry Ordway from the list of associates of Henry Tenon, the people that he's close with, you're left with one person, the person with the motive, the person you bring to a crime, the person who wants you to commit that crime and is going to help you succeed in your endeavor. If you're Henry Tenon, you don't bring a witness, you bring Mario Fernandez to complete the mission he wanted you to complete. You bring your co-defendant. And we'll never know where Mario Fernandez really was that night because his phone stops communicating with the cell tower. And not just stops communicating with the cell tower, it stops recording those timing advance recorded data points. Even though there's a number of them before the murder, and even though there's a number of them after the murder, there just happens to be none of them. Starting at 7:10, when they end here on the slide, through 8:20. And there is no incoming, outgoing, text calls, etc. Agent Blythe testified even if you are on Wi-Fi at your house, your phone will still interact with the cellular tower and still record data in those records and still record those timing advance. And he said it's much more likely and makes more sense based on the totality of everything that the phone was off or in airplane mode, rather than it just happened to have connection issues on the timing advance and just happened to not be using his phone at the same time. And another thing that happened to happen here is that the last timing advance data point recorded is at 7:10:28 p.m. And when you go back and watch that surveillance video of the homicide truck leaving Pablo Hamlet before Jared Bridegan's killed, it pulls out at 7:12 p.m. So his phone, if it goes into airplane mode, as I'm arguing it does, or is turned off, is a minute and a half before that truck pulls out. And do you know where Mario Fernandez's residence is in relation to that truck parked at Pablo Hamlet? Over a fence, over a gravel parking lot. A minute and a half. In its totality, there is no other reasonable inference or explanation than he was getting in that truck to drive it, to take Tenon down, to complete the mission that he wanted accomplished. No data. Mr. Dreisler brought out in cross-examination with Agent Blythe that there are other data points we didn't make a slide for, and I really wish we would have made a slide for, this gap, if you want to call it, between 9/11 and 10:02, because that also coincides with that truck coming back to Pablo Hamlet, turning into that gravel lot, and then disappearing from sight. So if there's a gap there, it also happens to be during a time frame when that truck can't be seen. I'm sorry, when Mr. Tenon is coming back to that truck. So the gap at 8 p.m., Mr. Fernandez's phone turns back on at 8:20. We know that truck pulls into Pablo Hamlet at 8 and then pulls immediately into that gravel lot. And then this time frame, 9/11 to 10 p.m., we know that is when, based on the surveillance, Henry Tenon is trying to get back to that truck, trying to meet back up with the person in the truck, to get his keys, to get his phone, whatever he's doing. And that time gap here happens to be when Tenon and that person are successfully meeting up, because Tenon got his keys back. We know that because he ended up at Potomac at the end of the night. And here is a view of the back of Mr. Fernandez's home. This is the lot for, the front lot for the Discovery School, and the headmistress testified today that there is also that lot, as Detective John said, near the retirement community and at the back of the school. So over this fence, through this lot, around the back, into that back gravel lot is a reasonable inference you can make from the available evidence. February 17th, who does Mr. Fernandez spend his whole day with? John Biggerstaff. And John Biggerstaff said to Mr. Dreisler on cross-exam that Mario Fernandez didn't tell him about this murder, even though we know Detective Burrell and Detective Lamont made that notification late that night. Mr. Biggerstaff said, I think he told me a couple days or a week later, after I'd seen it on the news, he said, the kid's dad died. But this whole day where he's driving around setting up chairs and tables for a wedding, according to his testimony, Mr. Biggerstaff's, doesn't say a peep about this humongous event in his stepkid's life, his wife's life, his life, doesn't mention it. And you can decide based on your analysis and weighing of how credible Mr. Biggerstaff is if you believe that they didn't talk about it. They were talking about it. Ask yourself, what do you think they were saying? What do you think they were talking about? February 28th is a very interesting day as well in the timeline here. This is the day that the defendant, on those bank records, transfers $50,000 from his flagship account to First Choice Home Rentals. $50,000 that should have gone to the Shanna Gardner Irrevocable Trust Fund, because he's getting disbursements from Shelley and Sterling Gardner, $75,000 in December 2021. He's the trustee of the trust. I would posit to guess, and you can use your common sense, that in-laws aren't giving their son-in-law a $75,000 present for Christmas of just because. You can assume as the trustee that that money was earmarked for the kids or for Shanna or for the trust. It's in his personal account, and on February 28th, he moves it to First Choice Home Rentals. February 28th is the same day he talks to the Jacksonville Beach police and schedules an interview with them the following day. And remember, February 28th, March 1st. February 28th is the day before March 1st. So the transfer of the money is February 28th. February 28th, he speaks to detectives to arrange his interview. And February 28th into March 1st, he deletes 5,342 artifacts from his Google Cloud Drive. Now, individually, people who go meet with the police might delete things from their phone, maybe. Collectively, and in its totality, Mario Fernandez going to speak to the police about the murder of Jared Bridegan that occurred 2.5 miles south of his house on a date night deletes 5,300 items. And then March 1st, he's interviewed. March 2nd through 6th, there's this, again, on its own, fine, it doesn't prove guilt. Maybe you can explain it away. It's when you view it in this timeline that it becomes significant. He takes an unplanned trip. How do we know it's unplanned? Because he's Googling, mapping Pittsburgh on February 28th. That same day he's deleting, moving money, and arranging his interview. He goes to North Carolina. He also Google Maps North Carolina. He goes to visit a man named Victor Quiras that he has never met in person, who knows him by his video game handle, who he's only spoken with via headset, and he stays on his couch. Then he drives to Pittsburgh, calls and gets a hotel for 2 nights, buys toiletry items, and then whilst talking on the phone, when you look at those phone records, to Shanna Gardner, Shanna Gardner's sisters, and Shanna Gardner's dad, Sterling Gardner, turns around and drives straight back without staying that second night in Pittsburgh, without staying another night back to Jacksonville. After his interview, while A, B, and LB are set to go have their interview with police. And again, taking a road trip on its own is not evidence of guilt. But when you combine it with the bookend of all those deletions and the moving of the money and his interview and this investigation, it becomes more significant, and you can make a reasonable inference from this. March 9th, the truck photos are released to the media. March 10th, Henry Tenon and Mario Fernandez have a phone call of 1,638 seconds, which is about 27 minutes, the day after that picture of Henry Tenon's truck is released to the media. A 27-minute phone call with his evicted, squatting tenant, the day after the truck is released to the media. Again, having a call with your landlord, or ex-landlord rather, on its own, not significant. But this number being much higher than any of their previous calls or any of their subsequent calls on that date is something that you can rely on in rendering your verdict. I included in the evidence with Detective Ostertag, who did the phones and the Google downloads, and the analyst, Lindsay Butler, some of the defendant's emails from 5239 Potomac. And I did that because there's a stark contrast between Mr. Fernandez's emails, calendar invites, invoices with Bueller Air Conditioning, and the complete lack of any documentation for these checks written to Henry Tenon for work. You will see those emails. You will also see that following the installation of a new air conditioning unit at Potomac, the defendant prepays, he buys a service package. And the service package is supposed to run from September 2022 to September 2023. He's doing this work on Potomac, and the reason that's significant or becomes significant is later, after Henry Tenon is arrested, and within 2 weeks, the defendant is calling home buying, flipping construction companies and short selling that house that he had a contract going the entire year to follow. This shows you that, at least in March of 2022, before the police caught on to Henry Tenon, Mario Fernandez had no intention of selling that Potomac house. He was putting money into it. He was putting work into it. He was getting service plans. He had a lease with Jerry Ordway through December, at least. So that I'll talk about a little bit in conjunction with it later in the timeline. Then we get March 28th. We get the 2 checks that are dated. On March 29th, one of those checks is deposited. And on April 4th, the other checks deposited. And what Detective Johns was telling you, these are what he was talking about. When he's talking about check stubs, this is a bit from a business book. So you would have a book, this would be on the side, and then the checks would be to the right or to the left where you can see the perforation where they're torn out. You can see 27, 28, 29, they're not torn. The perforation is still intact. And it's possible, on its own that doesn't mean much, it's possible, like Mr. Dreiser said in cross-exam, that you could rip one out, and then rip the last one out with all three stubs attached and give them out that way. That's possible. But you have to look at it again in the totality. So these checks, Henry Tenon, $2,000 for landscaping and clearing. Unlike the checks Mr. Mizrahi showed you with Detective Johns for J.B. Coxwell, which is a corporation, actually sponsored with Jags, to Bueller Air Conditioning, which is a corporation with an email address and invoices, to Tri-H Construction, which is a corporation. He doesn't write what address on the subject line. Landscaping and clearing, don't know where. I'm presuming Potomac. Keeping up with the roof, $3,000. Keeping up with the roof. Not roofing, not replacing a roof, but keeping up with it. Repairing a shingle here or there, $3,000. And then, of course, the Kickstarter for $5,000. The Kickstarter, the business plan, the composition notebook from 2022 that also came with a bunch of his pay stubs and his payday loans and his child support wage garnishment paperwork. And there's been no evidence in any of their phones or any of their Google Drives or any of the investigation that there was an actual Kickstarter. July 18th, that tire is located at Potomac. Without that tire, we may have never solved this. Henry Tenon would have just been another name on a phone record. They never would have looked into him, gotten his phone, gotten his DNA, gotten his cell site. That tire is what solved the death of Jared Bridegan. I said in opening that it was a lucky find, but what I really mean is it wasn't luck. It was the hard work of the investigators in this case. The defense has conceded that Henry Tenon is the shooter. Henry Tenon that night was a man unconnected to Jared Bridegan in a car in an area with no license plate readers, with DNA on a tire that they could only match with a 1-to-1 comparison. It was almost the perfect crime. He almost got away with it. And Jack's Beach and ATF, all the investigation they did, all the cross-exam and the criticism of what they did or didn't do, they got it right. They solved the unsolvable crime. They did it by boots on the ground, by going door to door, by getting hours and hours and hundreds of houses of surveillance and locating that truck on camera. They did it by going and talking to people associated with the only people who had motive against Jared Bridegan. They didn't leave stones unturned. They didn't just not talk to people. It was a pain, and it's annoying, and it's tiresome to drive all the way from Jacksonville Beach to all these random places and hope someone has some information. And it's not luck, it was good detective work and a little bit of luck that led them to solving this. If not for that tire, this defendant wouldn't be here today, and you all wouldn't be sitting in that box. There it is. And there's the house, and you can look at the roof yourselves. We get to August 18th. Jacksonville Beach Police has taken their time with this investigation. They don't arrest Henry Tenon for murder just based on a tire. They arrest him for unrelated charges to further their investigation. They take a DNA swab from him. They recover a phone from him. They start sending out these search warrants to get his cell site data. And that is when they see the geolocation in Jack's Beach the night of the 16th. They keep investigating. That's when they see the cell site and geolocation going to St. Johns County on January 29th. So when Mr. Dreiser was asking Detective Johns about not getting surveillance in Nocatee in January of 2022, it's because they didn't even know who Henry Tenon was. They didn't have his phone number or his phone or his location data or his download until August of 2022. You're not getting surveillance 6 months later from businesses and homes in Nocatee. You're just not. They're lucky that they got what they got. They're lucky they found that tire. They're lucky they worked hard. They put their boots on the ground. They knocked on doors. They were able to identify that person, Henry Tenon. And guess what? How did they find Henry Tenon? They found him through the defendant. They found him through his call records, through his rental property. They found the killer through Mario Fernandez, not independently. And when they found Henry Tenon and began investigating him, Henry Tenon led them right back to Mario Fernandez. He's the connecting thread in all of this. This was a point that I wanted to connect for you because it came out through several different witnesses. August 22nd, 2022, Detective Johns went and spoke to John Biggerstaff. You will see in John Biggerstaff's texts that that day he and Mario Fernandez met up in person. John said, the police came to talk to me. I was working at a school. You'll see in John Biggerstaff's text, August 22nd, Mario Fernandez and him texting the address of the school, where to park, where to go, how to meet up. And that the police came back later that night and they took John Biggerstaff's phone after he had gone and spoken to this defendant, after the arrest of Henry Tenon. And John Biggerstaff told you that Mario Fernandez had given him a heads up. They've talked to me, they might talk to you, and they might talk to my tenant. And when we got the download of John Biggerstaff's phone, even though he testified that there were years, decades of friendship with this defendant, and even though you can see in Mario Fernandez's phone, after the wipe, of course, and in Biggerstaff's phone, that there are hundreds, 70 text messages on the defendant's phone between him and Biggerstaff in the span of a week in August. There are no text messages between John Biggerstaff and Mario Fernandez left on John Biggerstaff's phone before May of 2022. And then, of course, August 26, 2022, Mario Fernandez factory resets, wipes his phone. Listen, I keep saying this. Wiping your phone in a vacuum doesn't mean you murdered somebody. Could mean that you want to sell it to T-Mobile, like the transaction they showed. Wiping your phone a week after your tenant is arrested, who owns a truck that looks like the one used in the murder, and you are told by police they're looking at him for murder, and then wiping that phone and keeping it, you have to consider that in its totality of what the significance of that is. September 5th to September 21st, the defendant, you'll see in his emails, he contacts a home buying company, Atlas Homes, and he makes these Zoom appointments on September 5th and September 7th to talk to them. And then by September 21st, about a month after Henry Tenon is arrested, the defendant signs a purchasing agreement for 5239 Potomac to quick sale it to Atlas Home Buying for $90,000 and asks to close remotely by mid-October. Mr. Dreiser put into evidence the defendant's post-nuptial agreement. In the post-nuptial agreement, the downtown house was valued at $70,000. August 2019. So he bought that house. It's worth $70,000. We know in March of 2022, he put $14,000 of work in it for that new AC unit. We know he's been doing work on it. So he turns around after years of holding this investment rental property and sells it. Its value is $70,000, at least that we know of $14,000 in work to it, $84,000, and he quick sells it for $90,000. After signing a year-long service agreement and a lease with another tenant. That's what you call distancing. After Henry Tenon is arrested, this defendant wipes his phone, sells his house, and tries to put as much space on paper and on land between himself and Henry Tenon as he can. That is consciousness of guilt. Hiding evidence, deleting evidence, distancing yourself from evidence is evidence of guilt itself. October 6, 2022, before the remote closing on the 12th, there's a search warrant executed at 5239 Potomac by the ATF and Jax Beach Police. The house Here you can see the garage, the roof, the landscaping, the old pallets junked in the back. Appears to be in a state of disrepair. Despite the poll cam footage showing bringing in buckets and brooms and bags of unknown items, there is no tile in the majority of this house. It's been ripped up, the sink is off. And then it states 205, this is what Potomac, 5239 Potomac looks like. This is a Google Map photo of March 2025 after the Atlas homebuyers bought it, looks like renovated it. So this is, using your common sense, you can decide how much money you think that roof costs and that landscaping costs to make this house look like that. October 14th, the truck is recovered. The truck that matches the truck from these still shots in the surveillance states 91. And Mario Fernandez at this point is living in Orlando, and we know from the teacher, Ms. Meredith, that Mr. Dreiser called this morning, that Ms. Gardner is living in Washington State with her children. She was able to, after Jared died, to have no further legal entanglements with him. She filed that death notice in their family law case, the one that Kirsten Bridegan testified that she asked Kirsten for Jared's death certificate less than 2 weeks after his death. She got full decision-making authority. She got more custody. She got her children and her freedom, and she packed her belongings and moved to Washington. And the defendant, according to Ms. Meredith, never saw those stepkids again. Then in January of 2023, Jax Beach Police has concluded their investigation. They have Henry Tenon's cell site. They have the videos. They found him on scene. They've collected items from the house, a pair of boots, a jacket. They found his truck with those check stubs. They found this boot box. And you get to decide, by the way. Detective Johns doesn't get to tell you. I don't get to tell you. Defense doesn't get to tell you. You get to watch those videos and you decide if those boots look like the boots Henry Tenon was wearing. The size, the appearance, the trim. You get to decide if that's the jacket he was wearing. You get to decide if this boot box belongs to these boots or some other boots in a photo, even though those boots don't have that black trim on them. You get to decide it. You're the finders of fact. And in the end, it doesn't matter because nobody here is disputing that that man on foot with the gun that shot Jared Bridegan is Henry Tenon. It just is a bad fact for them that Henry Tenon's clothing that he wore the night of the homicide is still at 5239 Potomac, even after he's been arrested and is in custody. At that point, the house that Mario Fernandez still owns and is doing work in and is trying to sell. And these clothing and shoes, they're collected months and months and months and months after the homicide. And if you watch that video, you see the shooting and you see Henry Tenon walking and then running away. So there is not much evidentiary value in these items because they've been in a dirty garage or in a closet months later. There's no evidence that Henry Tenon would have had any of Jared Bridegan's blood on him. He shot him from some distance away. You heard that from the ME by the lack of soot or stippling. So they collected everything at the time. They collected everything and they went and we put into evidence and you get to decide what value to assign it. But regardless of what you think, it doesn't change the fact that Henry Tenon shot and killed Jared Bridegan. And it doesn't change the fact that this whole timeline is replete with evidence as to this defendant's involvement. So January 25th, 2023, Jax Beach has done an extensive investigation, including finding Henry Tenon's DNA on the tire from the crime scene, the steering wheel of the truck, and the keys that unlock and turn that truck on. And there is a media announcement planned to get people talking on this wire. The people on the wire are going to be the defendant and his wife, Shanna Gardner, and these other people. And we heard some calls between this defendant and his friend, Carlos Fong. And on January 25th, the media announces there's a break in the case and there's going to be a press conference. And the defendant's statements to his friend.
How many times I've had a discussion with I've just had random discussions with strangers on top of that, with strangers. Yeah. And then I've had people that knew him when he was younger. Mm-hmm. you know, when he was in like high school or something like that. Because he grew up here in Jax or whatever. And they were like, I get it. And I was like, get the fuck out of here. Like, now you're coming out and saying some shit, but this.
He's talking with his friend, and he's saying that Jared was a jerk, and he knows people from Jared's high school and Jared's church, and they are talking bad about him. And he's saying that people are coming up to him saying, I get it. Get what? That's a weird thing to say when you're talking about to your friend after the media just said, hey, we have a big break in this case. But again, a statement on its own doesn't mean anything. It's the totality of all these statements on the wire call. It's what he said and what he didn't say on these calls. What he says is that he denies, go back and listen, he denies really having that much contact with Tenon. He tells his friend, I'm trying to remember conversations I had with him, any conversation that I had with him. He was a tenant. I kicked him out. He did some work for me. He doesn't mention we had phone contacts 70-something times during the 2 months the homicide occurred and right after. He doesn't mention that he continued to let him squat in the apartment even after he was evicted. He doesn't mention that he would go to the house and be there when Henry Tenon was there. That is the next day after they announced the arrest of Henry Tenon. He also talks about the work that Henry Tenon did for him. He doesn't tell Carlos Fong that he paid Henry Tenon $5,000 for landscaping, clearing, and keeping up with the roof. What he tells him is he gave him money to do some clearing and to mow that bee down. But listen to how Mario Fernandez talks to his friend about how much he's willing to pay for yard work.
Just to do, like, somebody gave me an estimate for a single tree, and I was like, $3,000. And I was like, yeah, no, go fuck off, dude. No fucking way. You know what I mean? So I was like, hey, you want to fucking knock off some branches and fucking plow this bitch to the ground? And that's what he fucking did.
What he didn't say is I paid this late day laborer, homeless man who's squatting at my residence $2,000 to take down a tree, but I wouldn't pay a reputable tree service's invoice for $3,000. And look, I get $1,000. That's a third difference, but it's not like he's paying Henry Tenon a couple $100. This is a significant amount of money, especially given what you know about Henry Tenon's income.
And however they're going to want to.
One of the things he says on the wiretap is he's talking about how the media has been portraying it. But what he's saying is that from the outside looking in, how people see this situation makes sense. Even the defendant is acknowledging like the reasonableness of this motive and the reasonableness of this story. From the outside looking in, that he understands. He says in the first wiretap call, they were looking at us for obvious reasons. Even to him, his attorneys can argue all day they have no motive and it doesn't make sense. Even he acknowledges it makes sense that the media is looking at us. It makes sense the police is talking to us. The police are talking to us.
And however they're going to want to paint it. And then obviously it comes down to whatever the fuck, you know, is said afterwards. So it's a 50-50 swing looking at it that way. But the other part is it's actually not even. It's more like a three-way split, because then it was there's this guy, then there's me, then there's Shanna.
He's acknowledging that he, from the outside looking in, is the link between Shanna Gardner and Henry Tenon, this person they just arrested for killing her ex-husband. Carlos Fong does something interesting on these calls, which is that he gives this defendant these like softball explanations to seize on. Like, listen to it. He says, hey man, maybe this guy, Tenon, thought he was killing you, not Jared. Maybe he's got beef with you. And this defendant says, nah, that's not it. No way.
I guess something broke out today about that whole situation we talked about.
Mm-hmm.
So they arrested some guy that used to rent the motorcycle house.
I know.
I was like, what the? So I guess he thought it was you. Because I think the motive was after you, not her husband. Her ex-husband.
Yeah.
I'm like,
Or,
yeah.
oh, dude, no way. You think so?
But he rented your house, so he must have had he probably didn't pay you, kicked him out or something like that.
I mean,
remember this, there's a possibility of that area.
Right.
Yeah.
There's no way, though. Like,
So his friend is telling him, maybe he had a motive that we don't know about. And the defendant's telling Carlos on that recorded wire call, no, there's no link between Jared and Henry Tenon. Carlos asked him, did he ever see a picture of him, meaning Jared, as an explanation of why Henry Tenon would know who to kill. And Mario Fernandez says, no, I didn't talk to Henry Tenon about Jared. I didn't leave a picture of him around. That's what their conversation is. I know it's hard to hear. When you go back there, you'll be able to listen to it better. But he's giving him these explanations of innocence. And the defendant's saying, nope, that's not it, bro. It doesn't make sense. No way.
I'm on.
That's the, you wouldn't have had any pictures of him, meaning Jared. He says, yeah, no, F no. The other thing that's interesting about these wire calls is that what the defendant doesn't say to his friend. He says, I gave him some money for tree work and roofing. He never tells his friend, I also made an investment in this guy's company. I gave him a charitable donation. I gave him some Kickstarter startup money. He doesn't say that to his friend because it doesn't make any sense. His friend's giving me all these theories that don't make sense. He doesn't say that. That is important. He doesn't say it because that check does not make sense given what you know about Henry Tenon and given what you know about this defendant. What he doesn't do, he is talking to Carlos following that first jail call about him and Shanna separating, but it was amicable, it's fine. The media announces, we are about to make a big break in this case. And then they announce the killer of Jared Bridegan is Henry Tenon, the tenant of First Choice Home Rentals, an LLC owned by this defendant 60% and Shanna Gardner 40%. What is the first thing in your mind you think someone in that position with that relationship would do when they hear, they caught the person, there's a big break, there's an arrest, this nightmare's over? He never calls Shanna Gardner, and she never calls him. Why? They have arrested someone that knows them, that killed the father of her children, the father of his stepchildren, when the media has been blaming them, and they don't call each other. Because it's not surprising to them. It's not new information, and they don't want to be in contact with each other. Mario Fernandez and Shanna Gardner want that distance between them. February 6, 2023, we seize the defendant's phone, we see it's been wiped. And then March 16th, he's arrested. June 4th, 2023, we had that very, very strange testimony from Juan Biggerstaff about a burglary of what he called the worst pool car in the entire Irving Police Department. Was stolen out of his driveway in a suburb of Dallas and abandoned a quarter mile down the street. And he made a report that the only things taken were his service weapon from his time as a police officer and a firearm with a serial number that happened to match the serial number of his father's unaccounted for Glock 10mm firearm. Between Fred Barton, John Biggerstaff, and Juan Biggerstaff, there's truth somewhere. And you have to ask yourselves, who's telling the truth? Who has an interest in lying? Who has an interest in protecting themselves, their friends, or their family? Who ended up with those 10mm firearms? Fred Barton said it wasn't him. Does Fred Barton have a reason to lie to you about that? Does Juan Biggerstaff have a reason to alibi his father's gun for him? Does John Biggerstaff have a reason to lie about where that firearm is? because it is a Glock 10 millimeter that's used in this homicide. And a few words about a Glock 10 millimeter. It is not an one and only gun in the world. I'm sure a lot of you are gun owners. Everyone understands that. We live in a capitalist society, and guns are products. So they make them, they sell them. But it's not that common. It's not a 9, it's not a 40. And if it had been a 9 millimeter or 40 used in this, we may not have had all this evidence, we may not have solved this. But when Mr. Mizrahi asked John Biggerstaff, a self-proclaimed gun enthusiast, do you know anyone else that owns a 10 millimeter? John Biggerstaff chuckled. He laughed and said, no. I don't know anyone other than myself that owns a Glock 10 millimeter. Other than the shooter, of course. The convicted felon shooter with no money in his bank account and nowhere to lay his head is somehow going to procure a firearm that has value, that is not that common, not like a 9 millimeter that's passed around the streets easily. The murder weapon has still never been recovered, but Juan Biggerstaff accidentally writes the serial number down wrong on a police report, a police officer. And he testified that he did so because he used that record to make his police report. Juan Biggerstaff, a police officer, doesn't keep a log of his own firearms, including his service weapon and other weapons he owns, like a list of them in his gun safe with his ammo in his gun, like most firearms owners. Instead, he wants all of you to believe that he kept a barely legible handwritten copy of his dad's 2016 federal firearms affidavit as the reference point for him, that he kept it all those years to remember what serial number he has for the 4 guns his dad gave him. It is clear that if John Biggerstaff gave that firearm to Mario Fernandez to give to Henry Tenon, wherever it ended up, nobody can find it. And if we had it, we could compare it to these shell casings and we could exonerate John Biggerstaff. But we can't. People don't get rid of evidence that's helpful to them. People don't get rid of evidence that's helpful to them. Guns don't just disappear. They're valuable. They're dangerous. Police officers aren't so uncareful with their weapons. And plenty of convicted felons possess firearms and don't get caught. Plenty of people don't take a magistrate's order seriously. That's clear because John Biggerstaff didn't really take it very seriously on pre-trial. He said he shouldn't do drugs. So he ended up going back into custody and serving time. So just because a magistrate or a law or a judge tells you not to do something doesn't mean people do it. Otherwise, I wouldn't have a job. I wouldn't be standing in this courtroom talking to juries like all of you. Agent Mick Stengel, a firearms instructor from the Bureau of Alcohol, Tobacco, and Firearms, also testified that in 18 years of experience, he's never seen another 10 millimeter in a case. Knowing someone who owns a 10 millimeter by itself doesn't make you guilty. In the totality of it, you decide what significance to assign to all of this. The evidence together proves that this defendant was involved. He wanted Jared dead. He solicited Henry Tenon to do it. He asked for help from John Biggerstaff, whether planning or provision of the firearm. He incited it. He encouraged it. He assisted it. He is guilty as a principle of murder, and he is guilty of solicitation for the ask, for the act. Later this afternoon, after your lunch break, you will hear argument from defense counsel, and then Mr. Mizrahi will have the opportunity to speak to you again. I anticipate that the argument will be that there is no DNA that connects Mario Fernandez to that crime scene. There is no witness that puts Mario Fernandez at that crime scene. There's no surveillance that puts Mario Fernandez at that crime scene. There is no photos or DNA or evidence or ballistics testing that put a 10 millimeter firearm in the hand of Mario Fernandez, handing it to Henry Tenon. And that is because of the nature of this crime, the almost perfect crime, designed so that there would be no link to this defendant, designed so he would never get caught. How can I show you a text between Mario Fernandez and Henry Tenon about murdering Jared Bridegan when they have deleted all of their texts? How can I show you the geographic location of Mario Fernandez the night of the homicide if he has turned his phone off?
You want to be heard?
No, Your Honor.
Okay. I'll sustain it.
Henry Tenon is not available as a witness in this case. Henry Tenon and Mario Fernandez committed this crime together, and Henry Tenon can't be here to tell you about their conversations. There would be no way in the world this defendant would write murder on the subject line of a check. Of course, he would launder the money. Of course, he would make it look legitimate. Of course, he would hope and pray and expect that the Jacksonville Beach Police Department would just never, ever, ever figure out it was Henry Tenon and never figure out the connection to him. If you outsource your murder, you are doing it so that your DNA and your footprints and your fingerprints are nowhere near the crime. When I spoke about the defendant and Ms. Gardner being the architects of Jared Bridegan's murder, that's exactly what I mean. If you are an architect, if you design a house and pay someone to do the painting, of course, there is not going to be the architect's DNA on the paintbrush. There's not going to be surveillance of the architect buying the supplies. There's not going to be a witness saying, I saw the architect painting this house. That's what solicitation in principle means. That doesn't mean that the architect didn't plan it, want it, finance it. And it doesn't mean the architect wasn't satisfied with the outcome. Individually, you can explain anything away. But a reasonable doubt is not a possible, speculative, imaginary, forced doubt, a guess, conjecture, or proof beyond all doubt. There is always some possible, hypothetical, made-up explanation for something. But you cannot go down that path. You have to look to the evidence and the testimony and your common sense. All of the evidence. This is the last portion, and then I'm wrapping up, I promise. The Getty Museum in New York City did this exhibit on textiles. What they did was they showed microscopic views. So what you see here is a fabric, and when you look at it under a microscope, ancient fabrics, you can see the minor defects, the imperfections in the threads, the weaving, the wear and tear over time. And then in the exhibit, when you pull back, you see how the threads are woven, how they connect, and what the tapestry shows. The law does not require a microscopic view of the evidence. It does not require proof beyond all doubt. It does not require perfection. No matter what you look at individually, how close you look at it, when you step back and see how it all relates together, the witnesses, the testimony, the motive, it is clear that it makes sense. No matter how much you look at these individually, you are going to keep coming back to this conclusion. You can test it, you can argue it, you can play devil's advocate, but there is no other conclusion that makes sense other than this defendant had Henry Tenon killed Jared Bridegan. It is unexplainable in any other way for all of these to add up together. And if you think that there is no reasonable doubt that he aided, encouraged, incited, solicited, or was there that night, then you have a duty to find him guilty. And that brings us to your verdict, which is the truth. For those of us that do work in homicide, we have an expression. To the living, we owe respect. To the dead, we owe the truth. Your verdict will forever define the death of Jared Bridegan and the responsibility
Overruled.
It will forever define the death of Jared Bridegan and the responsibility and culpability under the law of those that planned it, of those that wanted it, and of those that made it happen. The shooter was a stranger. The murder was personal. This defendant is that thread that runs through that whole tapestry, and no matter where you yank, it will not come unraveled. It all comes together, and it all connects through him. Find him guilty as charged.
Thank you, Ms. Stifler. Members of the jury, we're going to take our lunch recess and return back for the remainder of the closing arguments. I'm going to remind you that at this point in time, since closings, I'm going to restrict the phones. Mr. Holman, I'm going to restrict the phones, okay? You can have your lunch recess, but because the evidence is being summed up, I'm going to restrict your phone use while we are in session today, okay? Leave your notepads on your chair. Follow the communication rules over the recess, and I hope that you all enjoy your lunch. All right, please let the record reflect that the jury has left the courtroom due to the extended nature. Normally, everyone may be seated. So generally speaking, when we close cases down, I wouldn't have given them access to their phones, so I'm not going to give it to them over the lunch recess. Was there any objection to that? No. All right. So after the lunch recess, we'll call this, it's 12:22, we'll call it 12:30. We'll return back at 1:30. The defense will be set up for a closing argument. Okay. If there's something that comes up, let me know. You all enjoy your lunch. Court's in recess.